Hi, I'm Andrew Veale, a litigation attorney. Today, I'm going to talk about the responsibilities of a fiduciary and what happens if those duties are breached. First, let's review what a fiduciary is and some of their typical responsibilities. A fiduciary is a person who legally manages financial affairs for the benefit of someone else. In terms of estate planning and probate, a fiduciary could be your executor, your trustee, a power of attorney, or guardian, as each of these roles assumes the management of another person's money or property. A fiduciary is obligated to protect the interests of people entitled to the assets of a trust or estate, to disclose all material facts to the beneficiaries of the trust or estate, and to exercise the degree of care that a reasonably prudent person would devote to their own affairs. Now let's talk about what could constitute a breach of fiduciary duty. Here are a few examples. If a fiduciary is self-dealing in some way, this could include taking the beneficiary's assets for personal use or selling property to friends or family at a bargain rate, or overpaying themselves. While fiduciaries are allowed to receive payment for their services, excessive compensation is considered a breach of fiduciary duty. Also, making poor or improper investment choices, or intentionally pilfering or stealing assets may also be considered breaches of fiduciary duty. Ultimately, if a fiduciary does not act in accordance with legal and ethical standards, that fiduciary may face liability exposure and lawsuits. In a breach of fiduciary duty situation, a lawsuit needs to show three things. Number one, a fiduciary relationship is established. 2, there has been a breach of that duty. And 3, the breach of that duty is the proximate cause of the person's damage or harm. If you think there's been a breach of fiduciary duty, or you need help navigating this type of situation, contact us to discuss your matter.